thank you very much for this kind invite to share with you some of my thoughts on this important subject, which is the role of lawyers in promoting good governance. I don't take this opportunity lightly, as the appropriate response to this question has a direct bearing on how business specifically and our country in general functions. It is also important that this eminent institution that has gathered us all together here, an institution of thought leaders on matters of governance in our region, should focus in this matter, as our lawyers play an important role in promoting or sometimes undermining good governance in our country. This is much more pronounced in the context of a series of corporate scandals and governance failures, which have sadly become a common feature in South African economic and political life. In all of these matters, lawyers and auditors feature prominently, either in facilitating transactions or failing to prevent transactions that fall hopelessly short of the appropriate good governance standards. For purposes of our discussions, therefore, governance in this instance refers to the exercise of ethical and effective leadership by a governing body towards achieving governance outcomes of ethical culture, of good performance, effective control, and legitimacy. Then generally, lawyers, those of us that are in the private sector, are an extension of the company secretarial services, where we provide much more broader work than what the company secretaries are doing, whether it be due diligence, whether it be contract negotiations, contract drafting, and in the case possible of all mutual, long drawn-out litigation. But I'm certain that many that are gathering here today are familiar with one Brian Berger, who in 2012 published in the Review of Banking and Financial Law an article entitled "The Professional Responsibility of Lawyers and the Financial Crisis." He quotes the former Chief Justice of the United States, Harlan Fiske Stone, who once lamented that modern business and finance has made the learned profession of an earlier day the obsequious servant of business. Although neither the model rules of professional conduct has imposed any duties on lawyers in the wake of financial crisis, now is the time of reflection, during which lawyers should reevaluate their role in business transactions. He argues that lawyers should be trained to better understand finance, economics, and their clients' motivation. Business lawyers must recognize that clients' actions can cause harmful consequences that are not immediately obvious, that market participants do not always see or appreciate the potential harm their actions may cause, and that individuals often suffer from conflicts of interest due to compensation incentives occupying the unique role of lawyer or counsel. So a risk-conscious lawyer may have the opportunity to curb this hazardous corporate behavior. Wherefore, lawyers should inform their clients of potentially harmful consequences and consider withdrawing from representation if their clients persist in harmful actions,